Hello and welcome to the Minimum Competence episode for Wednesday, May 3rd, 2023. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. In today's episode, we have a Chevron challenge getting taken up by SCOTUS, a new filing deadline for the Third Circuit, Louis Brisbois mass exodus, Ford wins a big reversal, and an insider trading NFT case. Let's question everything we know about Wednesdays as we work through today's legal news. The Chevron doctrine is a legal principle that has been in place since a Supreme Court decision in 1984. It states, in sum, that when Congress passes a law that is unclear or ambiguous, the courts should defer to the interpretation of that law made by the relevant federal agency responsible for administering it. The doctrine has been used in countless cases and has provided support for agencies to make decisions on complex issues without explicit instructions from Congress. Now, the U.S. Supreme Court has agreed to review the Chevron doctrine. The doctrine has been criticized by conservatives for years as fueling government overreach. The case taken up by the Supreme Court, Loper Bright v. Raimondo, centers on the requirement by the National Marine Fisheries Service that certain vessels fishing for herring off the Atlantic coast must hire monitors for conservation and management purposes. The challenge is being mounted by 4 New Jersey fishing companies who want the rule invalidated and Chevron pared back more generally. Conservative groups are organizing against the doctrine, with the case described as a, quote, textbook example of the conservative legal movement manufacturing a case. The U.S. Court of Appeals for the Third Circuit has adopted a new filing deadline of 5 p.m. effective from July 1st, despite opposition from a group of 43 appellate lawyers who stated that the new deadline was, quote, undesirable and counterproductive. The deadline change applies to documents filed after the initiation of a proceeding in the court, but not to documents initiating an appeal or other proceedings. The court said that the move was aimed at improving work-life balance and avoiding late-night filings that deprive opponents of hours to consider and formulate responses. The new rule ends a practice by some of intentional late-night filings. At least 125 lawyers from Louis Brisbois are leaving the firm to join a new offshoot boutique, Barber Rainin, which has been launched by former leaders of its employment practice. Barber Rainin's founders, John Barber and Jeff Rainin, said they were yearning for an opportunity to build something on their own. The majority of the departures are California-based labor and employment attorneys. The mass exodus roughly halves the size of the firm's employment group, which had about 200 attorneys nationally. A federal judge in Detroit has reversed a jury verdict that ordered Ford Motor Company to pay Versata Software $104.6 million for breaching a licensing contract and misappropriating trade secrets. The judge said Versata had offered sufficient evidence of a contract breach, but not enough to let jurors calculate damages accurately. The jury had no basis to determine how long Ford would have needed to develop 3 trade secrets it allegedly stole, so the damages award was voided. The judge ordered Ford to pay Versata $3 for breach of contract. The $104.6 million award was about 85% of what Versata had sought. $3 is less. The trial of Nathaniel Chastain, a former product manager at OpenSea, the world's largest NFT marketplace, began with jury deliberations. He is accused of making more than $50,000 in illegal profits by buying NFTs before featuring them on OpenSea's website and then selling them when their value rose. Prosecutors have charged him with 1 count of wire fraud and 1 count of money laundering, alleging that he traded on inside information to profit. This case is the first insider trading case in digital assets, and its outcome could have broad implications for assets that don't fit into existing regulations. Legal experts said the case could affect investment advisors, brokers, and others trading on material non-public information. Chastain's attorney argued that the trades did not break OpenSea's rules and that the case was about whether Chastain intended to defraud OpenSea. And with that, thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. If you have any questions or comments, find us on Mastodon on the esq.social instance. Reviews go a long way towards helping new listeners to find our show. If you have a moment and can leave a rating or review on your podcast player, we'd appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. We'll see you back here tomorrow, and until then, remember, there is a Wikipedia entry that is just a list of portmanteaus. What are you doing with your day that is better than reading these? Golden Doodle? Beefalo? These are gold. Sharktopus?